Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. I am, of course, attorney Andrew Branca for the Law of Self-Defense. Starting up this first day zero, I guess, of the Alec Baldwin trial, jury selection. Finally, we are here. Talk about the Alec Baldwin murder trial. Sorry, manslaughter trial. Homicide trial, but manslaughter. Involuntary manslaughter. So on October 21st, 2021, actor and producer Alec Baldwin was on the set of the low-budget movie Rust. He was in a church on set. He was practicing drawing his imitation Colt single-action Western-type revolver from a cross-draw holster on his waist, pointing it towards the camera, cocking the hammer, putting his finger on the trigger. Photographic evidence of that while he was practicing. And at one point, tragically, he drew that pistol, pointed it directly at cinematographer Halyna Hutchins, cocked the hammer, pressed the trigger, and that gun made a loud noise. There was a live round in the gun. It discharged. The bullet struck Halyna Hutchins under her right armpit, traversed her body side to side, broke her spine, exited the left side of her body, struck director Joel Souza, who was standing behind her, embedded itself in his shoulder. Halyna Hutchins was mortally wounded. She would die as a result of this gunshot injury. And that death and Alec Baldwin's conduct is what led to his charge under New Mexico law of involuntary manslaughter, essentially a reckless killing. Reckless is distinguished from negligence. Negligence is only adequate for civil liability, not criminal liability. It's where you create an unjustified risk of harm to others and harm results, but you were not consciously aware of that risk. You should have been aware, but you were not actually thinking about it. You did not deliberately disregard a risk, an unjustified risk of harm to others. Recklessness is different than negligence. Recklessness is a higher level of mental state. It is sufficient for criminal liability. Recklessness occurs when you knew you were creating a risk of unjustified harm to others and you deliberately ignored that risk and harm resulted. The classic example of a reckless homicide is drunk driving. So you get drunk at a bar, you get behind the wheel of the car drunk. You're not intending to run anyone over on your way home. You just want to get home. In fact, you want the opposite of harming anyone. You want to get home without running anybody over. But you know when you get behind the wheel drunk and you're operating a motor vehicle that you're creating an unjustified risk of death to others. And if you happen to hit Granny in the crosswalk on the way home, that is an involuntary manslaughter, a reckless manslaughter. So that's the parallel to the situation that we have here. Alec Baldwin knew at the time that he was holding a real gun in his hand, capable of firing bullets. He deliberately pointed that gun directly at Halyna Hutchins. We know that because the bullet struck her. He cocked the hammer. We know that because he says he did that. And he pressed the trigger. And we know that despite his denials, because when the gun was tested, it was only possible to make the hammer fall from a cocked position when the trigger was pulled. Unless the hammer was struck by a mallet hard enough to break the gun, which obviously was not happening when Alec Baldwin fired the fatal shot into Halyna Hutchins. So that's where we are currently. This has been going on for quite some time. The shooting was October 21st, 2021. I wrote my first legal analysis on this on October 22nd, the day after 2021. And of course, we had very limited information then. But anytime you're handling an inherently dangerous instrument and death results from your handling, it's going to look a lot like manslaughter. Because if you're handling an inherently dangerous instrument, that's an instrument that everyone universally recognizes, if not handled with due care and circumspection, can readily result in death. This could be heavy machinery. This could be explosives. This could be dangerous drugs or chemicals. This could be a gun. A gun is an inherently dangerous instrument. We all know that guns can readily kill if not handled in a safe way. That's why there's 4 rules of gun safety taught everywhere in America, for sure. Treat all guns as if they're loaded until you determine that it's not. Never point a gun at anything you're not willing to destroy. Never put your finger on the trigger unless you're prepared to make a loud noise with that firearm. Know your target and what is behind your target. Those are the 4 rules of gun safety. And it's important to note that they're largely redundant. Well, the Rumble stream may just have failed, folks. I hear we're not on Rumble yet. There was a hiccup when we set up the Rumble stream. Let's see if I can fix it. Let's see if I can fix it. Make sure we're working on the law of self-defense dashboard. Sometimes Rumble has hiccups, folks. It's not as stable a platform as some of the others. Let's see. Law of self-defense member stream is working correctly. And let's take a look at X. Well, I'll have to see if I can fix Rumble on the fly. I don't know if that's possible or not. I swear, Rumble is a bit of a pain. I need a producer here in the office. Where's my producer to do all this for me? This is why I start the show early. Ba-ba-ba-ba. Yes, I know. Nothing but the highest production value. Oops. Okay, I have to pick a time in the future. Thank you, Rumble. I can't just go instant live. So we'll see. All right, so those are the 4 rules of gun safety, and they are redundant. You have to violate more than one to have a genuinely tragic outcome, a dead person. If you don't make sure the gun's not loaded, well, all you have to do then is not pull the trigger or not point it at a human being, and you won't have a tragic outcome. If you do put your finger on the trigger, all you have to do is make sure it's not loaded and not point it at a human being, and you don't have a tragic outcome. If you do point it at a human being, all you have to do is make sure it's not loaded and you don't put your finger on the trigger, and you don't have a bad outcome. Really, folks, it's pretty straightforward. So Bup, 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 bup. Well, it looks like Rumble's just not working from StreamYard, folks. So sorry, Rumble people. You'll have to go to YouTube, I guess. Or if you don't want to do that, you could become a Law of Self-Defense member. For just 99 cents. 99 cents to be a Law of Self-Defense member. Right there, lawofselfdefense.com/trial, or scan that QR code, and you can join us on the member live stream. You'll be emailed directions for how to join us there right away, and you get all your questions and comments addressed for free. Try it out for 99 cents. 2 weeks, that'll get you through this trial for sure. After the 2-week trial for 99 cents, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. Try it out at lawofselfdefense.com/trial. Otherwise, the only comments and questions we address are super chats on YouTube, $10 minimum super chats, which I don't recommend. That's a foolish thing to do. Give your money to YouTube like that. $10 per question. That's crazy. That's crazy talk. And I'm going to give up on Rumble after this effort. I just give up on Rumble. Sorry, that's it for Rumble. So, what are we looking at in terms of the prospective sentencing for Alec Baldwin if he's convicted? A maximum of 18 months under New Mexico law. So, not looking at forever, but is looking at that long. It's kind of a long trial for a manslaughter with an 18-month sentence. Most states, by the way, would be more like 10 years for involuntary manslaughter with a gun. So he's very lucky that he killed Halyna Hutchins in New Mexico. I wonder if they will change this sentencing after this trial. But he's looking at 18 months. So most murder trials are like 2 days, sometimes 1 day, sometimes 3 days, average about 2 days. They just don't take very long, folks. So 8 trial days for a manslaughter trial with a maximum of 18 months, when the murder trial with a maximum of life in prison without possibility of early release does not look promising. Is only 1, 2, or 3 days. 8 days is a lot for manslaughter. So now I have to see if I can come up with the stream for the court. They shouldn't be in session yet. I went to Law and Crime earlier, and it looks like Law and Crime wants to charge people for watching the stream. I didn't think that was actually allowed. This video requires payment to watch. Hey, Shane, I see you're in the comments. If you could look around and see if you can find an unpaid court stream, I don't mind paying, but I don't want to pay for like Law and Crime talking heads. I just want the trial stream. Check out Court TV, although their audio yesterday was terrible. Court TV. Live. It doesn't look like they have anything scheduled for today. So, jury selection proper is, I believe it's supposed to begin at 11 a.m. Eastern time, 9 a.m. Mountain time. Lawyers are supposed to show up to the courtroom about 8:30, so in about 15 minutes. I wouldn't really expect any streaming from the court until 9 a.m. Mountain Time. But maybe they're not going to stream the jury selection. I don't know. In which case, I guess I get the day back to myself. Let me give Emily a call. And see if she can hop on a computer and take a look. Hello, Emily.
Yes.
You're on speakerphone with the entire audience of several hundred people.
Hello.
I'm looking for the live stream from the court, and I'm having trouble finding one. The common places are Court TV on YouTube and Law and Crime on YouTube. Law and Crime appears to want to be charging people. This video requires payment to watch, but I'm not sure. I don't think they're allowed to do that for a court stream. So I don't mind paying if I have to, but I don't want to pay for Law and Crime talking heads on the screen. I'm just looking for the trial stream.
Let me see what I can do.
And I'll text you. There's a New Mexico courts website as well, but it doesn't seem to have anything scheduled either. So I can't really hunt around on the internet while I'm entertaining an audience. No one's watching to watch me hit keys.
Okay. All right. Let me see what I can do to find it.
Okay. Thank you. All right. Let's see. Send Emily another potential link. And of course, anybody in the comments. Okay. Shane says, just do a search. Okay. There's Reuters, Fox, lots of people. Daily Mail. I like the UK news. AP. All right, let's see what we got. Well, they're outside the court. Everyone's outside the courtroom right now. I'm going to pick up Reuters. Let's see if there's any. There's volume, but no one's. Oh, look, you get to see the World War II aircraft shows I've been watching. Look at that. Best supercharging system ever. F4U5 Corsair Super Prop. That's a great channel, by the way. Greg's Airplanes or something it's called. He's got a world of insight on World War II aircraft. For a pilot himself, a commercial pilot. Okay. All right, I got it. Thanks, Shane. I appreciate it. I got Reuters up. I'll stick with them unless something better comes up. Yeah. Jefferson says, I think the paid long crime thing is a TV show, not the live trial. Yeah, I don't want to pay for that. That's trash. They don't know what they're talking about. All right, so we have the 4 rules of gun safety I just talked about. We also have, of course, the SAG guidelines. The Screen Actors Guild's Safety Bulletin, number 1. Safety Bulletin, number 1. Let's see. That's not the one I wanted. For all the people saying, well, you know, Alec Baldwin, he's just an actor. He can't be responsible for whether or not the gun discharges. Well, yeah, he can, according to the Screen Actors Guild and their Firearm Safety Bulletin number 1. As an actor, you are ultimately responsible for your own safety and the safety of your fellow cast members. Production, management, and crew are responsible for creating and maintaining safe conditions, but it is your right and responsibility to double check the setup to ensure your own safety. And whoops, that's the same one. And this specifically to the handling of firearms. General safe use and handling of firearms. Safety bulletin number 1 of all their safety bulletins. And folks, they have tons of them. Tons of them. The number 1, because they have them for rappelling, for helicopters, for car chases, for all the dangerous stuff you see in movies. They have safety bulletins. The number 1 is firearms. And what does it read? Refrain from pointing a firearm at anyone. At anyone. Any object at which you point a firearm could be destroyed. Did Alec Baldwin point the gun directly at Halyna Hutchins? Obviously, the bullet struck her. Any object at which you point a firearm could be destroyed. Are we to believe that Alec Baldwin, with his decades of experience in movies, many of them, movies and TV, many of them in which he was handling real guns, he told the detectives in his interrogation that he's really well trained in gun handling. Are we to believe he doesn't know this? That you point a real gun at something, it could be destroyed? Never place your finger on the trigger until you're ready to shoot. We have lots of pictures of Alec Baldwin placing his finger on the trigger when he's not going to be shooting or doesn't intend to be shooting. And we know this gun, when tested, the hammer could not drop from the full cock position on a live round unless the trigger was pulled, at least until the gun was broken. And it was not broken in the hands of Alec Baldwin when he shot and killed Halyna Hutchins. So we have those additional safety guidelines. Plus, we have the legal presumption of handling inherently dangerous instruments, which everyone knows a gun to be. So what might have been just civil negligence under other circumstances is automatically bumped to criminal recklessness when you're handling an inherently dangerous instrument, because it's simply inferred that you knew it could cause death or serious bodily injury. Not that, you should have known, but that it's impossible for you not to know. So you put a real gun to someone's head and you pull the trigger, you're creating a risk, unless you've ensured that gun doesn't have live ammo in it, for example. There's no way you can say, I had no idea. I knew it was a real gun. I knew it could hold ammo. I knew it could discharge ammo. I knew if there was a live round in that gun and I cocked the hammer and pressed the trigger, it could fire that round through that person's head. But I had no idea it was capable of inflicting death or serious bodily injury. No. Does not work that way. It's not the armorer's job to not point the gun at Halyna Hutchins. So everyone who wants to blame the armorer, of course, Hannah Gutierrez was charged also with involuntary manslaughter. In her case, not for the handling of the gun in the moment it killed Halyna Hutchins, but because she allowed live ammo to come on set, failed to prevent live ammo from getting into the gun. And she was tried for involuntary manslaughter earlier this year and convicted and sentenced to 18 months, the maximum, by this trial judge, Judge Sommers. So she was responsible for her recklessness. There's lots of recklessness here. David Hall's the first assistant director who has overall responsibility for safety on the set, who handed the gun to Alec Baldwin, we believe, and called out cold gun, meaning it was a gun insured to be safe, wrongly, obviously. David Hall took a criminal plea to a misdemeanor, negligent handling of a firearm, no time, home arrest, basically, is what he got. That same plea was offered to Hannah Gutierrez. She said no. That's why she went to trial on the involuntary manslaughter charge and was convicted, sentenced to 18 months. That same plea was offered to Alec Baldwin, and he said no. And that's why he's going to trial now. Well, more accurately, in the case of Alec Baldwin, they offered him the plea, and then he went on George Stephanopoulos and gave that lengthy interview. And the prosecution said, Well, all right. If you're not being cooperative on the plea, because the plea requires you to plead guilty, right, to negligent handling of the firearm. If you're going to go on national TV and say, no, you did nothing wrong, the gun just went off by itself, that's not consistent with the plea. So we take the plea off the table. And that's why Alec Baldwin is going to trial. And it's quite possible, in fact, it is the case, that both Halyna Gutierrez and Alec Baldwin are recklessly culpable for the death of Halyna Hutchins in their own individual ways. Halyna Gutierrez for not ensuring that there was no live ammo in the gun, and Alec Baldwin for a different set of facts, for pointing the gun at Halyna Hutchins, for cocking the hammer and pressing the trigger, and firing the shot that killed her. Two different set of acts, two different sets of recklessness. To each their own. So, multiple people, we know at least two already, have been legally adjudicated as having criminal culpability for the death of Halyna Hutchins, David Halls and Halyna Gutierrez. There's no reason we can't add a third, especially when it's based on the facts. A new theory of the case by the defense appears to be they're going to put a lot of weight on, well, for all we know, the gun was broken. The gun did go off by itself. There was some modification to the gun. There's really no evidence that there was any modification to the gun that would change how it fired. And in any case, whatever modification, hypothetical modification might have been made, when the gun was thoroughly tested by the FBI, it could not drop a fully cocked hammer on a chamber without the trigger being pulled. Couldn't do it. We have lots of video footage on the set of Alec Baldwin handling that gun, cocking it, the hammer stays in the cocked position. It doesn't just fall onto the chamber. It doesn't fall until he presses the trigger to discharge the gun. So all the evidence, 100% of the evidence, is that the gun was operating as designed. Not that there was there's literally zero evidence that there was any defect in the gun that led it to not operate as designed. Of course, Alec Baldwin's not being prosecuted for violating SAG rules. He's being prosecuted for acting recklessly, knowingly disregarding an apparent danger, unjustified danger of death or serious bodily injury to another person. Well, how do we determine whether that's proven? Well, we can infer to his knowledge the industry-wide safety rules on gun safety that he's been taught scores of times, including on this movie set, which he ignored. Whoops. What happened, Reuters? Reuters just went black. Is that everybody? Let's see. All right, here's somebody else. Here's AP. We even have some talking by somebody. No cameras in here, he was just saying.
Wow, they screwed us over big time.
The hammer did have quarter cock and half cock notches. If the hammer were to slip from a quarter cock notch, it doesn't have enough force to discharge to ignite the primer and discharge the round. If the hammer were dropped from the half cock notch, it would fall in between chambers because at that point the cylinder is revolving, so it can't fire around from half cock either. But there's no evidence that it was capable of falling from either quarter cock or half cock. Didn't happen.
Yep.
All right, I'm going to mute the sound. Just photographers. I mean, this is, in fact, I'm going to take it off because it's going to make people seasick, I think. This live event has ended. Is that Reuters? Oh, for Pete's sakes. So let's see. Let's see. Tuesday. Start my notes page, July 9th. Baldwin jury selection. So, just some housekeeping for um, not today. I think today will just be a morning show. The trial judge Morrow, uh, let's see. Has said she's only okay. All right. My World War II fighter plane show started up again on YouTube. Sorry about that. Let's see. The judge has said only 50 minutes per side for jury selection, which doesn't sound like a lot. They have to pick 12 jurors. It does not sound like a lot. Let's see. Where's my Baldwin master files? I'm going to open up a picture here of the judge while we're waiting. There she is. The lovely and capable Judge Marlo Sommers. She's been great. She's been great. Really impressed the heck out of me. Very good, well-reasoned rulings. Takes absolutely no crap in her courtroom. Is absolutely determined that this trial will end no later than next Friday, June 19th, even though all the parties don't believe that'll be possible, in large part because the defense appears to be just continuously dragging everything out. This was the judge during the Halyna Hutchins trial. This has been the judge through almost the entirety of these Halyna Hutchins related judicial actions. There was a different judge for a few weeks, maybe a couple of months at the beginning, but she's largely been in charge since. Presided over did I say Halyna Hutchins trial? The Halyna Hutchins trial, the Armorer trial earlier this year, and of course sentenced Halyna Hutchins. She's really good. I like her quite a lot. I think her rulings are reasonable. The ones that are for the defense, I think, are reasonable for the defense. So I've been very, very impressed with her, and she's very sensitive to time wasted, the risk of time being wasted. She just will not allow it. So for jury selection here, she's told each side you get 50 minutes. Now, if you've watched any of my high-profile trial coverage, you know that sometimes jury selection can take days, weeks, in some crazy trials. She's not doing any of that. So they're not going to bring jurors in one by one. From what I can tell, they did not do any kind of polling or survey of prospective jurors ahead of time, which often happens in high-profile trials. She's got two groups of prospective jurors, 79 people each group. So let's call it 160 people. And the lawyers are going to speak to, during voir dire, the court and the lawyers will speak to the jurors in groups of 79. 79. So they're going to ask, she'll ask a set of standard questions that are asked of jurors. Do you know any of the parties involved? Do you have any pre-existing beliefs that would prevent you from being unbiased and impartial on this case? Things along those lines. Universal questions that are asked of all jurors. And then the parties will be given a chance to ask questions of the pool generally. Do you have strongly held opinions about Alec Baldwin as a person, for example? Might be asked. And then if any of them raise their hands, they may be asked to follow up with one-on-one voir dire for like a minute or two each, or not. This judge has said she's going to be very, very quick with the banhammer, meaning she's going to be very, very quick to dismiss for cause jurors who appear to have any risk of being biased or incapable of being impartial. She's not going to get into in-depth interrogations with individual jurors. Either they're unbiased and impartial and they're seated, or there's a hint, there's a scent, there's a scintilla of reason to believe that they can't be, and they're gone. Bam, 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 until they get 12 seated, and probably 2 or 3 alternates. So it should be very quick. I mean, when you think about it, 50 minutes for 12 jurors, that's what, 4 minutes a juror? That's not a lot of time. 4 minutes for each side. But it does mean we'll probably get out of here this morning, that this won't drag into an all-day affair. And then we'll have our jury. And we can start tomorrow. Tomorrow will be opening statements, not today. So that's the judge. Let's see. Let me pull up the prosecutors. Oh, they don't have very good pictures of Carrie Morrissey. Let's see. Why are the pictures of Carrie Morrissey also unattractive? That doesn't seem. Here's one. The 2 lead prosecutors are Carrie Morrissey let's see. There she is. And Erlinda Johnson. Well, that's kind of a pain the way they do that. Move that over here so I can see everybody. Oh, Erlinda Johnson is much more careful to have some glamour shots. Much more careful than Carrie Morrissey. And I'll provide a little bit of brief background. In fact, let me quickly pull together one slide with both. See if I can do this quickly. Yeah, I know. I don't have a production team, folks. This is what you get. Okay, so there's Carrie Morrissey. Here's Erlinda Johnson. And let's see. Okay, that's better. So Kara Morrissey and Erlinda Johnson. Kara Morrissey is actually a career defense attorney who was called into this case as a special prosecutor when the elected prosecutor decided she was too busy to bother with this case. And I think that sometimes has tripped her up. She's an excellent attorney. She's been really good. She did very well. She looked like a star in the Hannah Gutierrez trial. Of course, the defense counsel there was Jason Bowles, who was absolutely terrible. Terrible defense lawyer for Hannah Gutierrez. So in comparison, Carrie Morrissey looked like a superstar. She does appear to struggle a bit more with the defense lawyers for Alec Baldwin, who are very high-level Manhattan attorneys, mostly civil litigation attorneys, very, very smart guys, and a couple women as well. But the two lead partners are two dudes. Now, they don't have a lot to work with. The facts and the law are not with them in this case, the defense lawyers. But they're doing, I think, as well as they can with the crap pie that Alec Baldwin, their client, has given them. But here we have the prosecutors, Carrie Morrissey. And I think maybe because she was struggling a little bit in the transition from being a career defense lawyer to being a prosecutor, here is Alex Spiro, it looks like. That's one of Baldwin's defense attorneys. Look, they got big Suburbans in New Mexico. They got the big limos. I wonder if they brought them in from New York. They probably flew them in to make sure they didn't show up in an Uber. These Manhattan lawyers. But I think in part to help Carrie Morrissey and the prosecutor into things, they brought in Erlinda Johnson. She was not involved in the Hannah Gutierrez trial, but she is involved in this trial. Oh, there's a baby. I wonder if that's Alec Baldwin's wife. That must be the nanny. I'll go back. Sorry. And there's Alec. There he is. That woman to the left is one of the defense counsel. That's LeBlanc, local New Mexico counsel. Yeah, this has to be the fake Spanish wife of Alec Baldwin. One of their several children, the baby, I guess that must be the nanny. She hired a pretty good-looking nanny. I'm not sure that's a good plan. There's Luke Nikas, the bald gentleman. He's one of the lead defense counsel. And Alex Spiro is walking in front by the sheriff there, past the press. Those are the two lead counsel for Alec Baldwin. They come across as complete New York City lawyer a-holes. But that's fine. I don't have any objection to that. They're certainly earning their money. They're zealously advocating for their client. And given how little they have, there's LeBlanc, Heather LeBlanc. That's the local New Mexico attorney. I think that's Baldwin's wife there. But given how little they have to work with, I think they're doing a good job. And I think if they had a case where they had something to work with, they'd be deadly. I think they're very, very good lawyers, as they should be. They're both partners with Emmanuel Quinn, one of the top 50 law firms in the world, I think. And they're based out of Manhattan. So it's not like they're going to be slouches. It does make them tiresome to listen to sometimes. And some of their arguments are just facially ridiculous. But they make them with a straight face and they make them with energy. So full credit to them. Again, they just don't have much to work with. Okay. Let's see. Emily's still trying to help me. But we have a stream now. Hopefully we'll go inside the courtroom. I hope we get to watch voir dire. LeBlanc may have a hairbrush. It's funny how frequently I've observed that legal counsel in many of these high-profile cases appear not to own a hairbrush. when they know they're going to be on national TV. Yeah, I don't know if they're going to be allowed to bring a baby into the courtroom. I don't think the judge is going to allow that. But maybe they just wanted the baby for the, for the cameras they knew would be outside the courtroom. Let's see. I need like 8 monitors. I've got 3 giant 4K monitors and a laptop. All right. Well, now AP has gone offline. I guess they're going to make me work for it. Let's see. Go back to Reuters. No, we do have some video clip here from Reuters. Nothing's happening. Herrera Judicial Center. So those are the prosecutors. Erlinda Johnson has been great. Very, very sharp. Okay, I can't be texting back and forth. They've been in a very, very small courtroom so far for the pretrial hearings, like really small, like maybe 4 sets of benches on each side. So really minuscule. But I believe today they're moving up a floor to a much larger courtroom. Can anyone get in? I mean, generally trials are open to the public unless the trial judge orders otherwise. But if there's going to be a surplus of people beyond the seating capacity, then there's some kind of constraint on who can get in. Yeah, I heard that Chandler Remington and Larry DUI guy are maybe in the courtroom. I know Chandler definitely was planning to be in the courtroom. I think she was there yesterday. It's not actually that far from me. Santa Fe, New Mexico is 4 hours from where I am, 4-hour motorcycle ride down I-25 from where I live. But I can do better coverage, I think, from for me, it's better outside the courtroom from the live stream, assuming I can get a live stream. Assuming I can get a live stream. Quinn Emanuel. Okay, so, well, they got a picture of him here with hair. That's not what I want. Let's see. Because he's shaving his head now. Well, that's surprising. It's so difficult to find. Well, I believe the jury selection proper in a different room from the courtroom they've been in. Should be starting at 9 a.m. So in less than 10 minutes now. And hopefully they'll be streaming. Now, I should mention, folks, that on Sunday, this coming Sunday, we will be doing a very special recap show. Sunday afternoon, we're going to have a big giveaway. I think we're giving away a total of $10,000 worth of stuff. Platinum Law Self-Defense Platinum Protection memberships. We're giving away a very special gift with a bang. It's a bit of a hint. And my good buddy, Adam Baldwin, not Alec Baldwin, but Adam Baldwin. Let's see if I can. See if I can pick up a good picture. You know what? I have a good picture. I have, let's see. I have a picture of me and Adam. There we go. Last summer, I rode, most years I ride my motorcycle out to LA to visit with friends, including Adam. So we had lunch. Adam, of course, from Firefly, from Independence Day, from Full Metal Jacket, from Chuck, from The Last Ship, and much, much more. I've known Adam a long time. He's not immediately related to the Baldwin brothers, including Alec Baldwin. He tells me they have a distant relationship connection back in Ireland generations ago, apparently, but not a member of the family. Not a particular fan of Alec Baldwin, particularly not a fan of Alec Baldwin's gun handling on the movie set of Rust. I've had Adam on the show previously to talk about this shooting. By the way, if you go to lawofselfdefense.com/Baldwin, you can find all the coverage I've done of this event so far. There it is at the bottom, lawselfdefense.com/Baldwin, including my interview with Adam some months ago. Let me see if I can find that real quick. That was around, I think it might have been before or during the Hannah Gutierrez trial. Where are you, Adam? Oh, here it is. I even used the same picture as the thumbnail. So it's this. Adam Baldwin talks movie set gun handling back in November of 2022. So it's been a while. I'll be glad to get him back on. But he'll be joining me on Sunday for our recap of the trial. So if you're interested in that, there's the link right there on the screen. lawofselfdefense.com/trial recap. It's going to be structured as a webinar. It's not going to be on YouTube. It's not going to be on Rumble. It's not going to be on Twitter. You do need to sign up for it because we are giving thousands of dollars of stuff away. And of course, we're having Adam on. So you do need to sign up. There's 500 seats, folks, is the maximum. There's almost 1,500 people watching this stream right now. So if you're interested in that Sunday afternoon recap, having a chance to win from among thousands of dollars in free prizes we're giving away, and enjoying my conversation with my buddy Adam Baldwin, that would be a good time for you to be there. That's what I would recommend that you do. Again, that's Sunday. I believe it's, I actually don't remember the time myself. Let me see if I can pull it up here. I guess I should know, right? Here it is. It is Sunday, July 14th, 5 p.m. Eastern Time, 2 p.m. Pacific Time. But you do need to sign up. Register for your 100% free spot there at lawselfdefense.com/recap. if you're interested in that, and I certainly hope you are. We'll go through all the highlights, little clips of the trial up to date. So those of you who don't have the opportunity to watch minute by minute coverage, that would be the way to go. Is Rust still coming out? I don't know if Rust is still coming out. I don't think so. I think there's too many. But I don't know. If it came out, I guess I would watch it. I like Westerns. All right, so let me try again to try to find this. Reuters, is Reuters back? They are back, but nothing's happening. 8:57. See? Another place you can sign up for, okay. Further live coverage is expected. Oh, we just had that. I wonder what it must be like to be one of these law tubers who has like staff. That must be nice. Let's see. Well, it says that's ended. Watch live, jury selection. That's Fox News. But nothing is streaming. Daily Mail, Associated Press. They still just have the that looks like it's from earlier. That's not live, right? No. Nope. So I'll put our recap screen back on while I'm waiting to see what happens. Is this still? All right, that's over. I can't find anything live streaming, folks. I see people saying they rarely show jury selection. That's not true. They show jury selection quite frequently, actually, in these high-profile cases. It may be that the judge feels they don't have the physical setup to do jury selection without having the jury shown on camera. Oh, someone says DUI guy is there, says no live today. All right. Well, folks, maybe it may turn out to be quite a short day then. Quite a short day. All right. Well, I guess I can take a little time and go through what happened yesterday. Yesterday was the final pretrial hearing on this case. They went through a whole bunch of motions. Okay, someone's sending me messages here. Salvador. Yeah, thank you, man. I appreciate it. Salvador Dali. But that's not a live stream anymore. I think we're not live streaming. But what I can do is go through some of the motions. So they went through a total of, let's see, 22 motions. 22 motions on the day before jury selection. The court went through. She basically gave each side 10 minutes each to argue these motions, and they worked through them for the whole day. And yeah, Baldwin's got the guilty haircut. It does look kind of stern, doesn't it? So I'll just go through each of these, and I hear people say that the defense or the state had big wins on these, and I just don't see it that way. So, if one side or the other is making what I think is a bad legal argument in a motion, like a ridiculous overreach, and they get ruled against, I don't really count that as a win for the other side. That's just the way the law is supposed to work. I would count it as a win for one side or the other if I would have expected the ruling to go the other way and they won. But if the ruling from the judge is just straight up what the law says it should be, that doesn't give anyone an unfair advantage. So I don't think it's a big win for someone to win on a ruling. That's just the law. That's just the way the game is supposed to be played. Yeah, so I understand there won't be a live stream of the jury. Sorry. We'll do this instead. So it's kind of hard to score some of these decisions. And a lot of the decisions the judge said, well, I'm just not going to decide this issue now. I'll wait until it comes up in trial. So who won on that one? Right? We don't know. But I'll step through these quickly because it was the whole day yesterday. So the first motion, state's expedited motion to exclude defense witnesses Ryan Winterstern and Christopher Zook. So Winterstern and Zook are two guys that the defense wants to bring in as producers, experts on producing movies. They're producers. Presumably, the defense wants to bring them in to say that that this was not Alec Baldwin's responsibility as a producer on the set. So one of the things the state has tried to do is said, well, not only is Alec Baldwin carrying criminal culpability for his reckless handling of the gun, but also because as a producer, he was especially aware of the need to maintain safety on the set. And so the defense wants to bring in these guys, Ryan Winterstern and Christopher Zook, as producers to say, no, producers would not be exceptionally aware of the need for safety on the set, I guess. The judge has been very unfavorable to the state position that anything Alec Baldwin did as a producer should result in a manslaughter conviction. Now, there is a civil theory of liability called vicarious liability, where a boss is responsible for the harms caused by his employees in the course of their work. But vicarious liability doesn't apply in criminal court, should not apply. And I agree with the judge. There's plenty here on which to convict Alec Baldwin of involuntary manslaughter. His personal handling of the gun that killed Halyna Hutchins. I think it's an overreach to go after some kind of producer criminal liability. And the judge appears to agree. She's very hostile to any hint that anything that Alec Baldwin did as a producer should result in a conviction on a manslaughter charge. And I agree. So these guys are apparently, Winterstern and Zook were being brought in by the defense to argue, to counter this state's producer liability theory. And the judge said they could testify. I don't think they'll actually need to, because I think as we learned when the judge spoke about later motions, she just doesn't want the producer liability mentioned at all in court. So was that a win for the defense that these guys would be allowed to testify? I mean, if the state's going to argue there's liability from a producer perspective, then the defense ought to be privileged to bring these producers in to contest that argument from the state. I guess it's a win for the defense. It's not a big deal, really. And in any case, I don't think they're going to be needed ultimately. The next motion was the state's motion in limine to exclude mention of civil suits against Baldwin or Rust. So here the state wanted to say, we don't want the jury to hear that there are civil suits brought by some of our state witnesses. So some of the people on the set who were witnesses in Hannah Gutierrez, they're suing Rust and Alec Baldwin for infliction of emotional harm and various other civil causes. And the state wanted the judge to say they can't be questioned about their civil suits. That's a ridiculous position by the state. What if they're suing, if they have something to gain by how this criminal trial goes? And if Alec Baldwin's convicted here, all those civil suits are automatic wins for the plaintiffs. So they have an interest in Alec Baldwin getting convicted. The plaintiffs in the civil suits do. It goes directly to their ability, to any potential bias, to their credibility, that they've got lawsuits against Rustin and Alec Baldwin. Absolutely, the defense should be able to talk about those, and that's what the judge ruled. They can ask state witnesses about the lawsuits they've brought, and that's the correct ruling. It's not even complicated. That's just what the law should be. So is that a win for the defense? I mean, I guess so, but it's just a law. So I think it was silly of the state to argue otherwise. Next motion, defense motion to preclude improper prosecutorial conduct. So the Kerry Morrissey in the Hannah Gutierrez trial kind of ran over Jason Bowles, the defense attorney for Hannah Gutierrez. He was a dope. And she kind of beat him about in the Hannah Gutierrez trial, sometimes in ways that were unpleasant. And this defense team doesn't want any of that kind of theatrics directed at them in front of the jury in this trial. And so they were asking the judge to rule ahead of time, hey, don't let the state get snotty with us, basically is what this motion is, what they're calling improper prosecutorial conduct. And basically the judge is, listen, I'm not gonna pre-rule on someone being snotty and whether that needs to be corrected. I'm gonna wait and see if you people, the judge is fed up with both sides. If you people can figure out how to act like adults in my courtroom, we don't have to worry about this. So did anybody win on that motion? I would suggest not. In fact, the judge said explicitly, she looks right at them, I am in control of my courtroom. She's great. I should pull her back up. She's I really like her. Here she is. Judge Sommers. I am in control of my courtroom. If you're behaving, the judge said, oh, by the way, another thing she said is like no verbal objections, not just speaking objections. So so let me change this back to the replay one. I think that'll be easier. Lawselfdefense.com trial. So we're doing a recap on Sunday, but it's a webinar-based recap. We're giving away thousands of dollars worth of stuff. My buddy Adam Baldwin's going to be there as a guest, but you have to sign up for it. So, I would encourage you to do that. Sign up for that Sunday event. We got 500 seats, and we have over 1,300 people watching this stream right now when nothing much is happening. So I would encourage you to sign up sooner rather than later. All right. The judges said, so it's common, it's not unusual for judges to say, I don't want speaking objections. What's a speaking objection? A speaking objection is when one party objects, maybe specifies the basis of the objection hearsay, and then goes on to give a lengthy explanation of why they feel that way. And often that explanation either has the purpose of or incidentally does influence the jury in inappropriate ways. It becomes a form of argument. And the lawyers are not supposed to be, it becomes a form of basically testifying by the lawyers. And the lawyers are not supposed to be testifying. They're supposed to be asking questions of witnesses, and the witnesses testify. So often speaking objections can be abusive in the courtroom. So it's not uncommon for judges to say, I don't want any speaking objections, meaning you can say object, the foundation, the basis for the objection. So it might be objection hearsay, objection relevance, objection no foundation, and that's it, period. And just to inform the judge what the record, what the basis of your objection was, but no lengthy explanations that turn into testimony. This judge, because of how contentious the parties have been, this Judge Sommers has said, I don't even want you to say objection and the basis for the objection, not even objection hearsay. If you have an objection, I want you to approach the bench. And the entire thing happens outside the hearing of the jury because of how much they've been sniping at each other. Now, the lawyers appropriately raised the concern that, Your Honor, we only have 8 days for this trial. There is a lot of sniping. There may be a lot of objections. And then every time we have to come to the bench to explain it, as opposed to just saying objection hearsay, that's going to take a lot of time. And basically, the judge told them, well, let's see how you behave. If you can behave yourselves, then I won't have to treat you like children and have you come to the bench every time there's an objection. She is definitely in control of her courtroom. So, bottom line, in terms of the defense wanting a pre-ruling to prevent improper prosecutorial conduct, for the state not to treat them in a snotty way, the judge says, I'm not ruling on this now. I'll make rulings as I need to maintain control of my courtroom. The next motion was a state motion to exclude medical treatment of Hutchins. So the state is concerned that the defense might try to argue it wasn't the bullet fired by Alec Baldwin that killed Hutchins. It was improper medical treatment after the fact that killed her. This would be very common in civil litigation. And remember, the defense team are civil litigators. So it's very common to say, hey, it's not our client who caused the death in a wrongful death suit, a civil suit. It was somebody else, and therefore they're responsible, or at least partially responsible. In a civil case, you can have degrees of responsibility and therefore degrees of financial liability for a harm caused. The state did not want the defense to be able to make that argument that it was the treatment that Halyna Hutchins, the victim here, received that caused her death. And the defense agreed. So the defense has strategically chosen to not make the argument that it was not the bullet that killed her. They're going to say, yeah, it was the bullet that killed her. It's just our guy is not legally responsible for the bullet being in the gun or for him firing the bullet. But they're not planning to argue that it was anything other than the bullet that killed Halyna Hutchins. So that motion was granted for the state, but the defense wasn't going to make that argument anyway. Next was a defense motion to exclude contextual evidence. That's probably not what the motion said as a title. That's kind of my paraphrase of it. The state wants to talk about the defense would prefer the whole trial to be only about the things that happened in the moments surrounding the gunshot on October 21st, 2021, the shot that killed Halyna Hutchins. The state wants to talk about lots of other things that happened on the set, like Alec Baldwin commonly pointed the gun at other people, muzzled other people on set, not safe. That he would use the gun as a pointer on other days on the set. Like, you go over there, you go over there. That's not really safe. That he, at one point, discharged the gun after cut had been called. Not safe. Now, the defense is saying, well, whatever those things might have been, safe or not, they were not part of the shooting of Halyna Hutchins the day of the shooting, which is what this manslaughter trial should be focused on. And the state's saying, no, because the argument is recklessness, and we're allowed to tell a contextualized story of recklessness. Because he wasn't just reckless that day, he was reckless throughout the set. And we're allowed to tell that story to the jury. The defense was basically characterizing it as propensity, character evidence. Not really. Although some of what the state was trying to bring in really does feel like character evidence. There has to be some proximity between the conduct and the shooting. For example, later on, there's another motion I'll get to, but the filming of Rust continued later after the shooting, but not on this set in New Mexico. It was completed up in Montana. And the state wanted to introduce evidence that up in Montana, Alec Baldwin was reckless again with firearms. Now, is that sufficiently proximate to the shooting of Halyna Hutchins that evidence of that should be allowed in for the jury to consider in the shooting of Halyna Hutchins, whether that was manslaughter? The judge would ultimately decide no, she's not going to allow that in. So these are obviously evidentiary judgment calls being made by the judge. By the way, all these arguments that are being made and the judgment calls made by the judge here are essentially final. So trial judges have almost complete discretion on these evidentiary decisions. Unless it's what's called an abuse of discretion, the appellate courts would look for an abuse of discretion to overturn one of these. It's such a high threshold, it's almost never found. So whichever arguments these guys are making, whether for the state or the defense, they got to get it right in the moment because it's over. There's effectively no appeal from any of these decisions. Let's see. The judge ultimately here decided she would allow evidence like video clips of the Alec Baldwin handling the gun at other days on the set, in part to show that the gun was functioning properly. So those are going to be allowed. But videos of him, Alec Baldwin, just acting like a rude a-hole, like shouting at crew, telling crew to hurry up, rush, rush, rush. The judge said, I'm not allowing that in. That feels like character evidence. Like you just want it in to show he's a jerk. But I will allow in evidence that shows him manipulating the gun in an unsafe way, or that shows that the gun was not defective, that it was operating as designed. So was that a win for the state or a win for the defense or a mixed bag? I think it was just a correct call by the judge. Alec Baldwin should not be convicted of manslaughter because you think he's an a-hole, a jerk. That's not what should happen. Next, there was a state motion to exclude irrelevant evidence and witnesses. So it's interesting. So the history of this is that there was an initial team of prosecutors, and they went to the grand jury, and they got an indictment, and then they had to quit because they had various conflicts. One of them was running for the legislature in New Mexico. Apparently, you can't be a legislator and a prosecutor. And so they quit, and Carrie Morrissey was put on. And when Carrie Morrissey was put on, there was still the gun had not been tested for defects yet. And this was raised as an issue. Alec Baldwin went on George Stephanopoulos and said, the gun just went off. I never touched the trigger, suggesting that there was a defect in the gun. And that's when the state decided, we should send the gun to the FBI and have them look at it. Make sure that's not what happened. Because if the gun literally went off by itself, then, maybe this wasn't manslaughter. We want to be fair. And the defense then approached Carrie Morrissey, this defense, Luke Nikas and Alex Spiro, and said, listen, even you're saying we don't really know. Maybe the gun was defective. So while this testing is being done, would you agree to dismiss the grand jury indictment from the first team of prosecutors? Because it may not be necessary. And wait on the FBI test results. And if it turns out the gun was defective, maybe you'll want to dismiss the charges. And if the gun wasn't defective, you're free to, go to another grand jury and get another indictment. And Carrie Morrissey, remember, a career defense attorney, so sympathetic to the defense, said, you know what, that sounds reasonable. I wouldn't want this indictment hanging over my head if it turned out, the FBI testing was going to show the gun was defective, hypothetically. So she dismissed the first indictment, but not with prejudice. She reserved the right to get a second indictment. And sure enough, the FBI test came back and said the gun was operating fine, as designed, did not go off by itself. So once she had that information in hand, Carrie Morrissey said, all right, went to a new grand jury, got a new indictment. And we're here on this indictment, this new set of prosecutors, this new indictment. But in the first set of prosecutors, they had hired an investigator who apparently was incompetent. And when Carrie Morrissey was brought on board to replace the first prosecutor, she looked at what this guy had done and said, this guy's incompetent. You're fired. Well, that guy didn't like being fired. So he wrote a nasty letter about how the investigation was bad and all this kind of stuff. And Carrie Morrissey said, well, I don't want him, the guy I fired for incompetence, to be brought as a witness. He wasn't involved with the second indictment, and I had to fire him because he was incompetent. So she didn't want him to testify. And ultimately the judge said, no, I'm going to let him testify. He's part of the investigation, at least the initial investigation, part of whose evidence is being used in the second indictment and in this trial. And it's always open to the defense to argue that the investigation was defective or compromised or incompetent. Every defense attorney is free to make those kinds of arguments. So she's going to allow that. Is that a win for the defense? I think it was a ridiculous argument by the state to try to get him excluded. I don't think he has any value to add. I think he is going to be shown to be incompetent. So I don't really think he's a good witness for the defense, but that's up to them. Something to keep in mind, by the way, I should have mentioned earlier, is they have 8 days for this trial. So this week, Wednesday, Thursday, Friday, and then the 5 business days of next week. The judge is adamant it's going to end by next Friday, July 19th. And the judge is very sensitive about it not running long. And at one point, the defense got a little defensive about this and said, Your Honor, it's not us that's dragging things out, even though it is. We'd be happy to do our part of this trial in 2 days. And the judge said, all right, you get 2 days. So of the 8 days, the defense gets 2 days. And she waffled a little bit. She said, if you need 3, I'll give you 3. But of the 8 days of trial now, the state's getting 5 to 6 days, and the defense is only getting 2 to 3. So everyone's pretty constrained, especially the defense. So with that time constraint, is it really likely the defense is going to spend much time with this investigator from who was fired by Kerry Morrissey? Probably not. But we'll see. Let's see. The next motion was defense motion to exclude evidence of Baldwin as a producer. The judge was very hostile to state efforts to talk much about a producer component of this manslaughter conviction. So she's not going to allow some kind of vicarious liability argument in this criminal trial. That's not going to happen. She will allow argument that as a producer, he would have been aware of the SAG safety rules. That part's going to be allowed in. But anything that bleeds into, as a prosecutor, he has some independent path to liability. No. What else? There was another motion on Ken Jorgensen. Ken Jorgensen is a witness for the state. He is a guy who helped draft these safety bulletins for the IATSE film crew union. He's their representative on the safety bulletin drafting group. So the state's bringing him in to talk about safety rules. The defense doesn't want him to testify. They're saying, well, he's not an expert on safety. He didn't write the safety rules. He just organized the writing of the safety rules. But the judge ultimately ruled that Jorgensen, the state's expert of the drafting of the safety rules, would be allowed to testify. But anything having to do with vicarious liability of Baldwin as a producer to get to a manslaughter conviction, the judge is hostile to, will not allow. Next motion, state motion to exclude defense argument about prosecutorial misconduct. The defense has thrown a lot of heat at the prosecutors, alleging they've engaged in misconduct. They've destroyed evidence. Literally, the defense argued that the grand jury indictment should be dismissed with prejudice and no trial should ever happen because the state destroyed evidence, which sounds horrible, right? The state destroying evidence. What they're referring to is that when the state sent the revolver to the FBI lab for testing, the FBI did a whole bunch of testing. And then at the end of the testing, they unintentionally broke the hammer and seared the gun by striking it with a mallet when they were doing an accidental discharge test. The state doesn't want those ridiculous allegations of supposed prosecutorial misconduct brought in front of the jury, and the judge agreed. She's not going to allow those arguments. Fair enough. That's just what the law should be. There was a motion from the state to not mention the possible punishment here. Generally speaking, in most states, juries have nothing to do with sentencing. There's a couple states where they do. But of course, if it's a death penalty case, then you need a jury finding for the death penalty. But absent death penalty cases, in most states, a jury has nothing to do with sentencing. They have no idea what the sentencing range is, what the punishment could be. They have nothing to do with the punishment phase of the trial, only the guilt phase of the trial. And the state wanted to make sure the defense was not going to say, if he goes to prison, it would be 18 months. Now, I don't know why they'd be concerned about that. Normally, because it's such a short sentence for killing somebody. But if it was 10 years or 20 years, the jury might feel, well, I mean, he is kind of responsible, but I don't think he should do 20 years. So in any case, the defense doesn't, the state does not want the defense talking about the prospective prison sentence, and the defense just agreed. So there was no objection. So nobody's going to be talking about the prison sentence possibilities in front of the jury, which is as it should be. In New Mexico, the jury has nothing to do with the criminal sentence. Sentencing is entirely at the discretion of the trial judge within the statutory boundaries. The state had a motion to exclude definition of reasonable doubt by the parties. So normally, the judge instructs the jury on the law. I personally think that the parties should be allowed to talk about some of these legal definitions in opening statements, because I think it provides a framework in which the jury can plug in the testimony they're hearing over the course of the trial. So what is a reasonable doubt? What is the threshold the state has to meet? In the George Zimmerman case, for example, their defense attorneys brought in a big poster board with zero evidence at the bottom and beyond a reasonable doubt at the top, and preponderance of the evidence in the middle, and clear and convincing evidence. And during voir dire, they showed this to the jury, and they said, listen, the state has to disprove, and that was a self-defense case, self-defense beyond any reasonable doubt. That's not this much evidence, or get my hand on camera. That's not this much evidence, or this much, or this much, or this much. It's this much. It's all the way up here. So you might believe that it's probably not self-defense. That's not enough to convict our client. You have to believe that self-defense has been disproved beyond any reasonable doubt. And that was allowed during voir dire. I think that should always be allowed. I think the jury should know the legal framework in which they're supposed to be plugging in the evidence, and not just hear about it at jury instructions at the end of the trial. But it's very common for judges not to allow that kind of communication of legal definitions, legal context to the jury by the parties. And this judge is not. So no one's going to give examples of reasonable doubt to this jury, even during voir dire, to prospective jurors, was the ruling here. I don't like that, but it doesn't particularly favor either side, I think. Then there was a defense motion and this is the 11th defense motion. The 11th motion decided yesterday. We're halfway through. There was a defense motion to exclude evidence from lay witnesses. So there was a bunch of testimony in the Halyna Hutchins trial by people on the set. Script coordinators, grip dollies, lighting people, camera people, medics. And the defense was trying to characterize what these people were saying as often being kind of opinion evidence. And if it's opinion evidence, they ought to be qualified as experts, and they're not qualified as experts for the things they were saying. So the defense was saying, we don't want these people talking, like we don't want the medic talking about how loud the gunshot was. She's not an expert on gunshot volume, even though she overheard the gunshot. And so it was really an overreach, I think, by the defense to unreasonably constrain testimony by these people by kind of trying to characterize their personal observations as expert testimony. The judge, of course, ruled, as she should have, that she's going to allow them to testify as to their perceptions, facts in issue, but if they are going to be asked for opinions on things requiring specialized knowledge or expertise, then they would need to be qualified as experts. I call that a win for the state. Let's see. A big one was the defense had a motion to exclude statements by the prosecution that contradict what they said in the Halyna Hutchins trial. So this was a big one because, of course, Carrie Morrissey was the prosecutor in the Halyna Hutchins trial, and she said Halyna Hutchins is responsible for this death. And the defense is now trying to say, well, if she said that Hannah is responsible in Hannah's trial, she should be prohibited from saying Alec Baldwin is responsible in the Alec Baldwin trial. Frankly, that's a ridiculous overreach. They're each responsible. They're each recklessly responsible, culpable for involuntary manslaughter for their own individual misconduct. Hannah Gutierrez for allowing live ammo on the set and not ensuring this gun didn't have live ammo in it, and Alec Baldwin for the separate acts of pointing what he knew to be a real gun at Hannah Gutierrez, cocking the hammer, pressing the trigger without ensuring there wasn't live ammo in the gun. It's two separate cases. And ultimately, that's what the judge ruled, that there was going to be no such constraint. The prosecution is allowed to argue the individual theories of reckless culpability for involuntary manslaughter for each of these defendants. Is that a win for the state? I mean, that's just what the law allows. So 13th motion, state motion to exclude summary of investigation. Oh, this is the OSHA report. So there was a report done by the New Mexico version of OSHA where they did not find Alec Baldwin responsible for the death of Halyna Hutchins, which sounds pretty good for the defense, right? Except when you learn that, well, OSHA never finds any individual responsible for anything. That's not their job. Their job is only to determine whether an employer has responsibility. So, of course, they didn't find Alec Baldwin individually responsible because that's not what they do. They didn't even consider the question. So the state doesn't want this OSHA investigation summary presented to the jury because they believe that it's misleading. Even though they don't disagree, the state doesn't disagree with the OSHA findings. They're just concerned it would be misleading. But the judge says, no, I'm going to allow it in. And then on cross-examination, which is what happened during the Gutierrez trial, you can question the OSHA guys and say, but isn't it true you don't even look at individual liability? And that answers that question. Let's see. Let's see. Oh, what the judge did say. So this makes it a win for the state, whether this OSHA report comes in. The judge did say, well, because the question OSHA asks is, was the employer responsible? I'll allow you, defense, to bring in the OSHA report and ask them, isn't it true you didn't find Alec Baldwin as an individual responsible? But if you do that, the state's allowed to respond. But what about his liability as a producer, as an employer? I'll allow the state to ask that question. And that opens the door to all the other producer questions, this kind of vicarious liability concerns. That up to now, the judge has said, all right, I'm taking those off the table. I'm not going to allow the state to talk about his producer role in the context of manslaughter. But if you introduce the OSHA report, that opens the door to that. And I will allow the state to talk about his liability as producer for the manslaughter. So that's a win for the state. When I do not expect the defense now to introduce the OSHA report. Next motion, defendant motion to preclude argument, evidence, testimony of the victim. Let's see. Oh, this was the very sympathetic testimony about Halyna Hutchins. She was wonderful. She was from the Ukraine. She escaped the Ukraine only to be killed by Alec Baldwin in freedom-loving America. That kind of testimony. The defense doesn't want that. The defense argument is it's irrelevant that Halyna Hutchins was a nice person, had overcome hurdles, was a talented cinematographer. Those all may be facts, but they're not relevant to the legal question here, which is manslaughter. And frankly, I agree with the defense. That's right. Alec Baldwin should not be convicted of manslaughter because Halyna Hutchins was a nice person. Just like he shouldn't be acquitted of manslaughter if she was a mean person. Just like he shouldn't be convicted, Alec Baldwin, should not be convicted of manslaughter because you may believe he's not a nice person. None of that should be relevant. Now, the judge agreed with that. Judge, yeah, her character, it doesn't matter. But the judge should say, but if you put Alec Baldwin on the stand, then that opens the door to questions about more of Halyna Hutchins' background. What led him to agree to hire her as a cinematographer? And in terms of people talking about Halyna Hutchins in the moments of her death, that can come in. So not generalized background about how awesome she was, how much her mother loves her, how she's got a husband and a child, that kind of background stuff, not normally coming in, unless you open the door to it. But the stuff about her in the moments of her death, well, that goes to her death. That's part of the manslaughter. That's one of the elements of the manslaughter criminal charge. So that will be allowed. Same with autopsy photos, unless they're, I mean, some of them are so apparently so grotesque that the state didn't show them even in the Hannah Gutierrez trial. But some autopsy photos, again, they have to prove death. So the judge is going to allow those. A bloody shirt, because Halyna Hutchins ultimately died of blood loss, will be allowed. But some of the more, the state doesn't intend to show the really grotesque autopsy photos. So, I mean, this bullet broke Halyna Hutchins' spine. Just to find that, they had to really open her up in autopsy. You don't want those photos in front of the jury. And the judge, I don't expect to allow them. I mean, she'll make the call depending on what exhibits the state puts up with regard to the autopsy, but I don't expect the state to offer those super grotesque photos, so that I don't think it'll be on the table. The state motioned to allow exhibits during opening statements. So this is a point of dispute between the parties. So they're going to do opening statements, and opening statements are not evidence. But often you can show photos and things like that as exhibits, illustrative purposes during your opening statement. Each party wants to know what exhibits the other side is going to show, because that kind of gives away the other party's strategy, and each side wants to know the other party's strategy so they can optimize their own counter strategy. And neither side is really informing the other of what their exhibits are going to be. To the extent they're required to inform of exhibits, they're providing a list of exhibits that's way longer than can possibly be used. So it's not of any real useful informational context to the other side. And so they were arguing basically about, well, we want their exhibit list that they're going to use in opening statements. Well, we want their exhibit list that they're going to use in opening statements. Nobody wants to go first, but it looks like the judge browbeat them into sitting down and actually coming to some agreement on that. And I think they did by the end of yesterday. Defense next was 16 was a defense motion to exclude evidence from the Crow filming. Crow, the movie Crow, was the I think it's Brendan Lee, the son of Bruce Lee, was acting on a set and was killed by a real gun on the set. And what appeared to happen there was an obstruction in the barrel, unknown, and a blank was loaded in the prop gun, which was a real gun, as they generally are. And the gun was pointed at Brandon Lee. And when the blank was discharged, the energy of the blank caused the obstruction to be propelled out of the barrel, and it struck Brandon Lee in the chest and killed him. So it wasn't a live round on the gun. It was just a blank round. And the state would like to introduce evidence of that because they believe that the defense is trying to say, well, the defense has been trying to say, our guy, Alec Baldwin, cannot be guilty of manslaughter unless he knew there was a live round in the gun. Not that there was a risk of a live round, but that there was a live round. And the state's response to that is, no. These guns are dangerous. They're inherently dangerous. Everybody knows that. Even with a blank, they can kill, as from the Crow movie. Well, the defense doesn't want the state making that argument about the blanks. So basically the defense is saying, well, blanks are irrelevant to this case because it wasn't a blank that killed Halyna Hutchins. It was a live round. And Crow is not about live rounds. It's about blanks. And therefore, any evidence drawn from that movie should be irrelevant here. And the judge was pretty tough on the state. The judge was saying, well, it's true, state, that you keep talking about live ammo. You're not talking about blanks. I read the grand jury transcripts, and, you're really talking about live ammo. And so ultimately, the judge ruled, listen, state, I'm going to allow your expert to make a one-sentence statement that blanks are also dangerous. But that's it. So no extensive evidence from about the Crow shooting. Let's see. At that point in the day is when the judge mentioned voir dire happening today was only going to be 50 minutes for each side. to get to a jury of 12. 2 pools of 79 prospective jurors. She's going to be very aggressive about dismissing for cause. She did mention that there's the sides have 5 and 3 peremptory challenges each. I presume that's 5 for the defense and 3 for the state. I'm not sure how important that will be, given how aggressive the judge has said she's going to be about dismissing prospective jurors for cause. She just wants, if there's a hint of cause, that juror is done. She'll move on to the next one. She's lined up 160 prospective jurors for a panel of 12 and a couple alternates. So the judge is convinced she can find 14, 15 out of 150 unbiased, impartial jurors to seat within a couple of hours. Next was a motion by the defense to exclude cumulative expert testimony. The state has lined up a number of experts. Brian Carpenter, who testified in the Hannah Gutierrez trial, as kind of a gun expert. Lucian Haig and his son Michael Haig as gun experts. Ziegler from the FBI as a gun expert. And the defense was arguing, look, they're cumulative and time is of the essence. Judge, you say you're concerned about time. We want some of these excluded. Jorgensen is going to be a movie set safety expert. It's only an 8-day trial. And the judge basically said, well, listen, it's an 8-day trial. Each side knows how much time they have. You, defense, have 2 to 3 days, and the state has 5 to 6 days. And I'm going to allow you to manage your own time. So that's how we're going to constrain concerns about cumulative evidence, is just by the time constraint. So I guess that was a win for the state because the judge didn't put any constraints on the state in terms of their expert witnesses, which is what the defense wanted. Now we're up to 18, motion 18 from yesterday. The state motioned to limit double hearsay on the CAD reports. So the CAD reports are the kind of transcripts of radio communication to and from officers. And often these CAD reports have misinformation in them, not because anyone's acting with malice, but because it's like people are calling 911, right? That gets transcribed to the CAD report. Well, often those people don't really know what's happening, right? In this case, Baldwin shoots Halyna Hutchins in the church, and people in the church start shouting, call an ambulance. And someone outside hears this and calls an ambulance and describes what they believe might be happening, but they don't have any first person knowledge of what's happening. They weren't in the church themselves. And so they end up communicating stuff that's wrong. For example, in this case, part of the CAD reports talk about the fact that Joel Souza was shot in the stomach. Well, he was not shot in the stomach. He was shot in the shoulder. That's just, fog of war, misinformation, miscommunication that happens. And the state did not want that stuff going in front of the jury because it causes confusion. And here the judge just said, listen, the CAD reports are largely relevant evidence. If there's obvious stuff that would cause confusion, I'll rule on that in the moment during the trial. I'm not going to make a prejudgment about that. Defense motion 19 from yesterday, defense to exclude improper opinion evidence from Paul Jordan. This is the Montana set. So after Halyna Hutchins was shot, obviously filming on the Rust set in New Mexico stopped. A period of some months went on, and then they began to continue filming of the movie, not in New Mexico, but up in Montana on a different set. And the state has one of the requirements of the film union for this filming on Montana was that there be a safety consultant assigned who had authority over Alec Baldwin. Alec Baldwin could not override this safety consultant's recommendations. And the state is saying that's exactly what Alec Baldwin tried to do. Even after killing Halyna Hutchins on a different movie set for this movie, he was still reckless up in Montana. And we want that safety consultant to come testify before the witness on how Alec Baldwin continued to be reckless. And the defense argument here was, this is really just character evidence, right? Whatever he was doing in Montana had nothing to do with his shooting of Halyna Hutchins, months earlier. And the judge agreed. This looks like character evidence to her. She's not going to allow that Paul Jordan, Montana evidence to come in. Is that a win for the defense? Well, sure, it's good for the defense. I think it's just a proper ruling by the judge. It's how I would have ruled. Again, I don't want, and I don't think this court wants Alec Baldwin to be convicted because he's kind of generally a bad person or generally reckless. He could be reckless 99% of his time, and if he was not reckless in the handling of this gun, if the gun was defective or a piece of the set had fallen on him, and that's why the gun discharged, I would not want him convicted of manslaughter here, even though he might have been reckless every other moment of his life. I care about what he was doing, whether or not he was reckless in his handling of this gun when it discharged and killed Halyna Hutchins. 20, state's motion to preclude hearsay by the victim. So how would you get hearsay by the victim? The victim's dead, right? Well, hearsay is by definition an out-of-court statement being introduced for the truth of the statement. Alec Baldwin, at one point, well after the shooting, said, well, I only pointed the gun at Halyna Hutchins because she told me to point the gun at Halyna Hutchins. Now, this is very weak evidence. First of all, it's self-serving. Second of all, he didn't say that right away, like during his hour-plus police interview. He gave lots of statements before he ever said anything about Halyna Hutchins saying to point the gun at him. Other witnesses say they didn't hear this. So it's very weak evidence. The state doesn't want, and of course it's hearsay. It's an out-of-court statement. The defense kind of ridiculously tried to argue that, well, it's not being introduced for the truth of the statement. It's being introduced for the effect on the listener. So it could be a lie, but if the listener believed it, for example, maybe Halyna Hutchins never said those words, but Alec Baldwin heard those words, like misheard something she was saying. Maybe she said, don't point the gun at me. And what he heard was point the gun at me. So the point the gun at me would not be introduced for the truth of the statement. The defense might say, no, we agree. Every other person in the church heard her say, don't point the gun at me. We believe that's the truthful statement. But we're not trying to introduce our statement, point the gun at me, for the truth of the statement, but only for the effect on the listener. It's one of the exceptions to the normal rule of exclusion of hearsay. And the state doesn't just want to have to deal with this because it's such weak evidence. Ultimately, the judge ruled that what the state was trying to say now was, all right, listen, if you're going to introduce it for the effect on the listener, that exclusion, that exception to the hearsay rule, then we want Baldwin to take the witness stand. Because he is if it's effect on the listener, he's the listener. And the judge said no. The judge said, no, state, there were other people in the church who may have heard the statement too, and they would be allowed to testify without Baldwin having to take the stand, because it would be reasonable to infer that he was in close proximity. He would have heard the same thing. So I guess that's a win for the defense. But again, that's just part of it, right? The defense gets to make their case too, and then the state has to overcome it. Next was a state motion to, is this the last one? Let me see. Second to last one. So motion 21 decided yesterday. State motion to exclude crew letters. So the defense went around to the crew of the movie set and asked them to sign a letter saying that in their opinion, the movie set was safe. And they managed to get 1/6 of the movie set people to sign this letter. In our opinion, the movie set was safe. 5/6 of the movie set did not sign the letter. Alec Baldwin did not sign the letter. And it's kind of ridiculous, right? Because most of these people, they weren't in the church. They didn't see how Baldwin was handling the gun. They have no firsthand knowledge of whether or not his handling of the gun was safe. And even if the movie set was generally safe, based on their personal knowledge, again, they weren't in the church. They don't know if this moment in time was reckless, which is what matters. And most of the crew didn't sign the letter. So it's all kind of silly, very low relevance to the actual facts, material facts in the case, relevant to the manslaughter charge. And ultimately, what the judge said was that she's not going to allow the letter in as general evidence. She will allow it in as impeachment evidence. So if somebody who signed the letter saying they believe the set was safe, if the state calls them as a witness and on the witness stand, they start talking about how they thought the set was unsafe on the witness stand, the defense will be allowed to bring in the letter to impeach them. Isn't it true you signed this letter saying it was safe? And that's just a proper legal ruling. That's exactly what should be allowed. And in the last motion from yesterday, defense motion to exclude Pieta testimony. This was a gross overreach by the defense. Pieta is the factory that actually made this gun. So it's a replica of a Colt single action revolver from the Western era with a loading gate and all that jazz. Now, it wasn't made by Colt. Colt doesn't make these guns anymore, but there are a couple of Italian companies that do make replicas of these, and Pieta is one of them. And the guy who owns the company, his name is Pieta. And the state wants him to testify as a witness, saying that, speaking to the design of the gun, the safety features of the gun, the quality control of the gun, directly attacking this defense argument about the gun was defective, what was the condition of the gun when it left the factory, and so forth. And of course, the defense doesn't want this. The defense wants to be able to say, oh, for all we know, the gun was defective when it left the factory, which is exactly why the prosecution wants to bring Pieta in to testify. And the defense was they used the local New Mexico lawyer to make this ridiculous argument. So the two big guys from the big Emmanuel Quinn law firm, they were not making this ridiculous argument. They sent in the local Heather LeBlanc attorney to make this argument. She was saying, well, for all we know, like, the gun just somehow transformed. Like the metal parts, even if they were robust when they left the company, maybe they turned into Play-Doh in the several years that passed between them leaving the factory and the gun coming into Alec Baldwin's hands. Very weak argument. The state, of course, said, listen, we're not asking Pieta to talk about the condition of the revolver on the set. We're only asking him to talk about the condition of the revolver when it left his factory. And of course, the judge is going to allow that. So very, very weak argument on that last motion. So the Pieta testimony will be allowed. A win for the state. I just think that's a solid ruling. And as I've been saying, I'm a big fan of this judge. I think she's great. Murray Marlo Summer. Now, sometimes judges, do a weird U-turn. We saw that in the Nikolai Mew, the Apple River stabbing trial, where I thought the judge was really good through the whole trial until it got to the jury instruction conference where they have to decide on the exact jury instructions the jury will get. And at that point, I thought the judge threw the defense completely under the railroad tracks, under the wheels of the truck. So hopefully that doesn't happen here. But so far, through the Hannah Gutierrez trial and through this trial and through all these pretrial hearings, and I've watched pretty much all of them. I believe I've watched all of them. This judge has been great. Judge Summer, Mary Marlo Summer. Awesome. She does have resting bee face all the time, but she takes no crap from either side. She's in control of her courtroom. Nobody doubts it. Everyone's very differential. No one's trying. They pull shit with each other, but they don't do it with the court. All right, folks. So again, I'm just going to remind everybody, we do have this recap we're doing on Sunday, but you do need to sign up. It's free. It's 100% free. But you do need to register for it because we're doing it as a webinar. We only have 500 seats. There's over 1,500 people watching this stream right now, and nothing's actually happening, right? So you can imagine we're going to have thousands and thousands of people during the actual proceedings starting tomorrow. And we only have 500 seats for the recap. So the recap will go over highlights from this week's events and much more. We're giving away over $10,000 worth of free gifts. Law Self-Defense Platinum memberships, lots of our educational content, some surprise gifts that are of a nature we've never given away before on Law Self-Defense. Things I think you will really like. Some of these mystery gifts are things I carry on my person every day. That's a hint. And my buddy, Adam Baldwin, not Alec Baldwin, Adam Baldwin, is going to be joining us as well. You know Adam Baldwin from Firefly, from Full Metal Jacket, from Independence Day, from the TV shows. Well, Firefly was a TV show. From Chuck, from The Last Ship, lots of other stuff. Great guy. Just as nice a guy in person as you might imagine. Fantastic guy. Been a good friend of mine for many years. Not really a relation to Alec Baldwin. It's definitely not one of the Baldwin brothers, per se. But very experienced in gun handling, done lots of movies with guns, lots of TV shows with guns, has had all the SAG safety training, very familiar with safe gun handling on sets. And I reached out to him yesterday, and he's available on Sunday to come join us for a bit. So I'm really looking forward to that. I'm a huge fan of Adam Baldwin. So to register for this, just use that QR code. I think you can, if you're watching this live stream, could somebody click on my QR code symbol for me? And then in the comments, tell me if that opens up a page. I'm told that you can click on it. I haven't tested that. I don't know if, I guess I could do it myself, right? I have, let's see. Why am I not? Oh, I got to go live here. Let me see. Okay, if I, no, it doesn't look like you. It works. Well, some people are saying you can't click, and some people are saying you can click. Yeah, if you scan it with your phone, it'll definitely work. So you know how to use QR codes, right? Even I know how to use QR codes. So you put your phone up there and scan it, or you type in that URL. I'm not allowed to say what the mystery gift is yet. I see lots of guesses. Some of those guesses are correct. So, yeah, I'm not sure if you can click it or not, but you can scan it. You can just remember that URL, lawselfdefense.com/trial recap, or you can do, if it's easier to remember, lawselfdefense.com/Adam Baldwin. It's going to be great fun. It's going to be an hour or 2 hours of a lot of fun, a lot of gifts. And I think you'll really, when you first meet someone, so I've always, to my mind, Adam's always been just a fantastic movie star. I've loved everything he's ever been. And so the first time I met him in person, I will confess, I was a bit starstruck. I was a bit tongue-tied. But he is such a nice, personable, what a great guy. As nice a guy in person as you could possibly hope for. And been a really, really good friend to me. Decisive friend in many ways, through difficult spots. Just a great guy. The opposite of how many of us think of Alec Baldwin, for sure. All right, folks. So I'm going to, I guess I'll go ahead and wrap up today's show. We're 2 hours in. That's what happened yesterday. And I am absolutely live streaming every minute of the trial, as I always do in these high-profile trials, starting tomorrow morning. No later than 8:30. I'll probably start at 8 o'clock and just be providing 8 o'clock. Sorry, 10 o'clock Eastern time, 8 o'clock Mountain time. The trial's taking place in New Mexico Mountain time, same as my time zone. And the trial, I expect it will be streaming trial proceedings 9 a.m., 11 a.m. Eastern time each day. I'll probably be here an hour earlier, so I can provide some background and some context. I might do separate morning and afternoon shows. I haven't decided yet, but that would give me a break. I would also like to do an end of day, like a 15-minute summary of highlights. That takes time to prepare. So I'm thinking of doing separate morning and afternoon shows so that during the lunch break, I can begin the preparation of that highlights reel at the end. I've never done that before. It's I will confess, it's very difficult to be doing like live real-time reaction to proceedings, and also simultaneously like being a producer and making notes of timestamps of stuff like that. But we're going to make the effort and see how it works this time, because I know most of you don't have time to watch every hours of trial proceedings. So we're going to try to provide a 15-minute, 20-minute summary at the end of the day. So that's what we're thinking in terms of nuts and bolts production. All right, folks. So with that out of the way, and again, don't forget that recap. The recap on Sunday, very important, because there's 500 seats. That's what we're doing. And let me take a look at see if there's questions I can answer from the Law of Self-Defense membership. And I guess I'll take a quick look and see if there's any super chats. I only answer questions from Law of Self-Defense members in the member chat, and they get their questions answered for free. Or it needs to be a $10 super chat on YouTube. Let me see if there's any supers. No, not yet. And I don't recommend that. I don't give $10 to YouTube per question. Become a member for 99 cents at lawofselfdefense.com/trial and get all your questions and comments answered for free. All right, let's see what we have from the members. Whoops. Well, it looks like it overflowed. Sorry, folks. I can only see the last 100 member comments. Someone was making holster recommendations. I'm looking at a new gun. So if there's good holster, Kydex, appendix in the waistband holster recommendations, if you put them in before, put them in again in the member comments, because I'd like to see those. And it looks like I missed them. Let's see. Somebody made a recommendation, said that there's an 8 to 12 week wait. Really good holsters often have a wait, folks, especially if they're custom made by a small shop. That's just the price you pay. Let's see. My current preferred holster maker is actually Keepers with a K, Keepers Concealment. They make great stuff, but they don't make a holster for the gun I'm looking at. So it's a low production volume gun. There's not a lot of holster makers for it. Lots of holster talk. Good heavens. I guess that's what happens when there's no proceedings. Let's see. Somebody mentions Wilson Combat. They make good guns. I put a lot of rounds through my Wilson Combat 1911. Something like 100,000 rounds. Just got it rebuilt and refinished by Wilson a couple months ago. It looks brand new now. It's amazing. I almost miss all the wear and tear on it, but it really needed. 4th time I've had it refinished. 4th time. But first time I've had it like rebuilt, like everything tightened up and new springs and all that done. Let's see. Yeah, for appendix in the waistband, Keepers Concealment makes a great product. They're very ugly. They're a little expensive. They can take a while to get, but I've been using them for years, and for me, they're a go-to. Definitely worth considering for appendix in the waistband. You forget you have the gun on you, which is perfect. Let's see. Yep. All right. Well, mostly it's gun talk, which is fine. One of the benefits of the Law of Self-Defense chat is the community. The Law of Self-Defense community gets to chat back and forth with each other about whatever they like. And holster recommendations are always fun. It's almost like caliber preference conversations. It's a never-ending conversation. So if you'd like to be part of that community, it's cheap, 99 cents, lawofselfdefense.com/trial for a 2-week trial. Gets you through this Alec Baldwin trial for sure. And after that, it's still dirt cheap. It's only 30 cents a day, less than $10 a month to be a Law of Self-Defense member at lawofselfdefense.com/trial. Hannah Gutierrez may testify. She's been subpoenaed, and the state has made the appropriate request to this court to order her production from prison. So I would expect that she will testify. There's a question about whether or not she's just going to plead the fifth. And then there will be argument. You can't plead the fifth about everything. You can only plead the fifth about stuff that could incriminate you. And then there's a question about whether or not the state had asked the court to grant Hannah blanket use immunity for this trial, so the state could compel her to testify. And the judge didn't want to do that, but we'll have to see how that all plays out during the trial itself. Milt Sparks makes great leather holsters. I haven't bought a Milt Spark holster in probably 20 or 25 years because I switched completely to Kydex. I don't know if they do Kydex now or not, but when back in the day, certainly they were making very, very high quality leather holsters. Fan of Milt Spark stuff for leather, but I don't use leather anymore. All right, I'm going to wrap up, folks. Thank you all for joining me. Of course, we'll be back tomorrow. I'll send out an email notification, and of course, schedule it on YouTube and in the Law Self-Defense member dashboard. And hopefully tomorrow we'll get Rumble working correctly. Sorry about that. I will put not that it matters. Rumble's not listening. Anyway, forget that then. All right, folks, I'm going to go ahead and wrap up. Just remind all of you, if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill. So my family is hard to kill. If you do any of that, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, tomorrow morning, to cover the actual opening statements of this Alec Baldwin manslaughter trial. Until then, I remain attorney Andrew Branca for the Law of Self-Defense. Stay safe.